I'm Bob Merlin. I'm a collaborative family attorney. I help people resolve their family differences without going to court. One of the processes I use as a Florida Supreme Court certified family mediator is mediation. Mediation is a process of using a disinterested third person, someone who's not a part of the divorce or a paternity matter, to help both sides resolve their differences, negotiate a settlement. That person has no power, cannot force anybody to do anything, and should not be telling either side what they should do. That person is sort of a facilitator to help both sides communicate with each other, especially on what they want to accomplish, what they want, what they're willing to do, and to help them come together, as we say, getting to yes and agreeing to everything so that you can have a final agreement. Mediation process is confidential, which means that nothing that is said during the mediation process can be used against you in court, so it encourages everybody to be open, transparent, and free to express their interests and goals. Mediation, usually in Florida, is during the pendency of a paternity matter or a divorce. So you're in the middle of court, and sometimes there's the threat during mediation that if you do not agree to something, then the other side is going right into court. You can go to mediation without even being in court, and you do not have to have an attorney when you go to mediation. A couple can decide to go to a mediator, and they can peacefully resolve everything and ultimately enter into an agreement that will eventually be filed with the court for the court to approve. When you go to mediation, expect to spend some time. Find out from the mediator how long the mediation is going to take. It can be set for a specific length of time, or maybe it's unlimited and it can go on for many hours. When you participate in mediation, you have the ability to say, I've had enough, I cannot be here any longer, I need to continue this mediation. So if you get too tired or you feel that you're drained and you just cannot be a part of the process anymore, ask to continue the mediation, and you have the right to do that. You may want to bring food or something to drink if the mediation is going to be for many hours. You want to know where the mediation is going to take place. Ask whether you're going to be meeting together, both sides, with the mediator, or are you going to be completely in separate rooms. Traditional mediation has everybody meeting together, at least initially, and it gives everybody an opportunity not only to express themselves, but to listen to the other side, to hear what they have to say. But most mediations in Florida never do that, and they wind up being in separate rooms. You have the ability to ask to do it one way or the other. I urge my clients to meet together because of the benefit of hearing each other and knowing what the goals are of each of them. You need to prepare for mediation. You must know what the facts are of your matter and have an idea of what the law is, because the law will have an effect. When you're in mediation, you have more flexibility than a judge does in a trial, so you're not necessarily bound by the law, but you should know what the law is, because if you do not resolve something in mediation, you have to know what your exposure is in court. Be patient. Mediation is a process. And be prepared to negotiate, because mediation is a negotiation process. If you think that you're going to go into mediation and get every single thing you want, that's probably not a realistic expectation. So be realistic in what you'd like to accomplish. And understand that as part of mediation, there's a give and take. You may want something that the other person will give you, but in exchange for something else. So you have to be prepared to give and take. Set your priorities. Determine what you must have and be prepared to give on other things. Sort of draw a line in the sand where this is something that I cannot give away in this mediation, and other things that you can give away in mediation. In my opinion, it's important and critical to be transparent in the mediation process, and actually in all of the processes I use for my clients. If you are not honest about what is going on in your relationship, then it's possible for you to enter into an agreement and to be attacked later and set aside so that you no longer have a valid agreement. Be transparent. There may be very difficult issues that have to be addressed, but be honest, and overall you're going to wind up being much better off by doing that. And make sure that you're getting transparency from the other side. If the other side is refusing to provide information to you, maybe you're not ready for mediation. Maybe you need to make sure that you get that information because it's so critical that you need to know it to be able to negotiate about it. Or maybe you don't care about the issue and you use that as a negotiating tool in the mediation. It depends upon your particular circumstances. If this was beneficial to you, please feel free to reach out to me. Leave a comment. I'll be happy to review it and respond to you. And if you think there are other people who would benefit from this, please invite them to view this video. And I urge you to join this network because I'll be seeing you again in the future.